Today, we will cover the top 5 most important things to know about moving an existing business out of California. But first, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications spanning accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. If you are contemplating the complex process of redomesticating your existing LLC or corporation out of California without the guiding hand of an experienced redomestication attorney, brace yourself for a regulatory quagmire that could ensnare your business in a web of statutory intricacies, fiscal pitfalls, and judicial perils. California's framework, governed by the labyrinth of the California Corporations Code and the revised Uniform Limited Liability Company Act, as amended and adopted in California, ostensibly permit outbound redomestications. But the procedural thicket is so dense with conditional mandates, interlocking filings, and potential tax triggers that even seasoned practitioners tread with extreme caution. What we will cover in today's presentation are the top 5 critical hypercomplex considerations that, if mishandled by an inexperienced attorney, or God forbid you're taking the DIY approach, could precipitate cascading disasters, from franchise tax board audits that metastasize into multi-year ordeals to inadvertent veil piercing that expose your personal assets to voracious creditors. Ignore these at your peril. Your enterprise's survival hangs in the balance. Number 1, navigating California's hyper-stringent conversion statutes amid interlocking jurisdictional overlaps. Now, California does, to be clear, and contrary to what you may have heard from other attorneys, does authorize outbound redomestications for both corporations and LLCs. But the process is a Byzantine maze of prerequisite internal approvals, multifaceted filings, and cross-jurisdictional harmonizations. For corporations, you must first orchestrate a board-approved plan of conversion that meticulously delineates asset valuations, member or shareholder voting thresholds, often requiring supermajority consents and continuity provisions to preserve the existence of the federal employer identification number. LLCs demand additional detail, including unanimous member consents, appraisals of intangible assets in some cases to avoid constructive distributions, and compliance with the laws of the new state, which must be reciprocally compatible or you are risking rejection. Botch the sequencing, say, by filing California's statement of conversion before securing the target state's approval, and you're thrust into a legal void where the entity is neither here nor there, triggering suspension by the California Secretary of State by non-compliance, with reinstatement fees escalating into the thousands of dollars amid accruing penalties. The complexity amplifies even further if your entity holds California real property, invoking transfer taxes or reassessments that could inflate property taxes exponentially. One misstep in this knot and your business grinds to a halt, exposed to interim liabilities that no DIY template can shield. Number 2, the California Franchise Tax Board's relentless pursuit of exit taxes and perpetual nexus entanglements. This is a big one. California's Franchise Tax Board has a reputation for being a leviathan and, in some cases, attempting to enforce a so called exit tax regime that can ensnare outbound movers through intricate apportionment formulas. Even post redomestication, if any whisper of nexus lingers, and by the way, nexus is a term of art, it has a very specific legal meaning, much more complicated than what you'll find with a quick Google search or query of Gemini or Grok. But I digress. If there is any indication of lingering nexus in the Golden State, such as sales sourced under market-based sourcing rules, retained employees triggering a payroll, withholding obligations, intangible property licensed back into the state, among others, you will remain on the hook for the annual minimum franchise tax fee or more via the multi-factor apportionment formula if sales exceed state nexus thresholds, plus potential deferred gain recognition on assets. Fail to file a final corporate or LLC return with precise asset basis reconciliations, and the Franchise Tax Board deploys its audit arsenal, including, among other things, automated notices escalating to liens, interest at eye-watering rates, which are compounded daily, and penalties up to 25% or more for understatements. Worse, California's water's edge restriction for multinational entities adds layers of unitary business analysis in some cases, potentially clawing back foreign income attributions. This isn't always a clean break. It is a fiscal stranglehold that can bleed your relocated entity dry for years with collection actions crossing state lines via interstate compacts, turning your so-called fresh start into a perpetual nightmare of compliance audits and enforced remittances. All of that, however, can be avoided by working with an experienced attorney and CPA who understands this particular niche. Number three, preserving entity continuity amid California's draconian documentation mandates. Maintaining seamless continuity of contracts, credit profiles, intellectual property rights, and operational licenses is a high wire balancing act fraught with California's exacting documentation protocols. Your plan of domestication or conversion must incorporate detailed exhibits in many cases, including, for example, audited financials to substantiate no impairment clauses, affidavits attesting to creditor notifications to avert claims of fraudulent transfer, and cross-referenced amendments to operating agreements or bylaws, ensuring governance structures align with the target state law. If you omit a single provision like explicit EIN preservation language, continuity will fracture. Banks will demand account re-verification, vendors will trigger force majeure clauses, and your business name faces preemption in the new state, obliterating your hard-earned brand equity and search engine optimization efforts. California's Secretary of State scrutiny amplifies this. Annual statements must reflect the transition without gaps, or you will face suspension, barring you from defending lawsuits effectively. And the result is a fractured entity hemorrhaging revenue while you attempt to scramble through corrective filings, all vulnerable to opportunistic litigation that exploits the interim chaos. Number four, triggering IRS and Franchise Tax Board audit cascades through misaligned federal and state reconciliations. This one is particularly tricky. California's redomestication interplay with federal tax law is a powder keg of complexity where even minor discrepancies ignite explosive, time-consuming audits. The Federal Internal Revenue Service views outbound moves as mere tax-free reorganizations, but California's conformity with deviations to federal law demands synchronized elections. Fail to mirror federal basis adjustments, and you invite so-called whipsaw taxation, the Franchise Tax Board assessing gains on intrastate assets while the IRS defers them. Your CPA's head will explode. Add California's net operating loss limitations and market assignment rules, and a DIY filing can reclassify the entire transaction as a taxable event, slamming you with immediate taxes on built-in gains, potentially up to a very high rate. And audits are inevitable in these cases. The Franchise Tax Board's multi-state audit program cross-checks with IRS data linkage, unearthing mismatches that balloon into major penalties, including up to 40% or more for substantial understatements and at very high interest rates. Subchapter S entities or pass-through LLCs face amplified difficulties, including, for example, inadvertent terminations, forcing entity-level taxation, and retroactive allocations that can potentially rewrite years of returns. This is not a minor hiccup or an oopsie. It is a multi-agency barrage that can consume your life for a decade. That's no exaggeration, with collections crossing state lines. And number 5, exposing yourself to so-called veil-piercing and alter ego doctrines under California's aggressive consumer protection judicial standards. Now, California's courts are notoriously plaintiff-friendly when it comes to piercing the so-called corporate veil, which, by the way, can apply to LLCs as well, especially in redomestication scenarios where the formalities are not appropriately and consistently observed. Incomplete plans of conversion or domestication, including those lacking exhaustive member approvals, asset inventories, or fiduciary duty affirmations, signal undercapitalization or commingling of funds, thereby inviting alter ego claims that can potentially disregard your entity's liability shield. Personal liability then attaches. Judgments for business debts can levy against your home equity, investment portfolios, even assets of your spouses via community property rules. Add to that mixture California's long-arm jurisdiction, and out-of-state moves don't necessarily shield you. Plaintiffs can haul you back into California courts for so-called minimum contacts with the state. Fraudulent conveyance allegations can further exacerbate this, with punitive damages and attorneys' fees shifting if intent can be inferred from rushed DIY filings. And the end game is, and I'm not exaggerating here, total personal financial destruction. I've seen it happen more than once, as well as the possibility of bankruptcy, plummeting credit scores, and the diminishment of future entrepreneurial opportunity. This isn't abstract legalese. It is the grim reality for those who underestimate California's judicial meat grinder by taking matters into their own hands or working with an inexperienced attorney. If you have questions regarding redomesticating your existing California corporation or LLC out of the Golden State, you should know my firm has handled many of these, and all of them with a success rate. That is to say, 100% of our redomestications out of the Golden State have been successful. If you are interested in discussing this matter with me, please use the link in the description below for more information on the process and for the opportunity to schedule time for us to chat about your specific situation. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations on this topic, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.